Okay, go ahead, Tony.
All right, I would like everyone to make yourself comfortable and make your technology work if you can. It's always a challenge sometimes. Try to remember that if you're not actually talking and presenting or questioning or participating in the discussion, to mute and that sort of thing. And we have three very good panelists today. Jacintha Webster from ECU is going to go first, and she's going to be discussing state tribal gaming compacts. Then Christine Pappas, also from ECU, will be discussing Native American environmental policy in Oklahoma. And then we have Ryan Haney from the Oklahoma Council of Public Affairs. He's going to discuss Oklahoma State Question 805. So everyone else just relax and enjoy and learn. I've been in and out of all the panels today, and it's been fun and a lot of good stuff out there. So after each panelist gets about 10 minutes or 12 or so, if you can time yourself, it'd be nice. Then we'll have a few questions from me, and then we'll open it up for discussion. So go right ahead, Jacintha.
Thank you. Well, let me start my timer. Thank you. Thank you so much for having me. I wanted to talk about tribal state gaming compacts, and not just those gaming compacts, but how the gaming compact controversy in the state actually led into an interesting discussion and debate about executive and legislative power and the separation of powers within our state. Because I think it's sort of an interesting, like, multifaceted conversation that we ended up having as a result of gaming. So first, I'm going to give a little bit of like a primer on gaming compacts. So tribal gaming is governed by the Indian Gaming Regulatory Act, or IGRA. And IGRA divides gaming into three different classes. So class 1 gaming are traditional games. That's like if you've ever been to seen people do stickball, hand game, chunky, anything like that. Those are traditional games. Those are wholly regulated by tribes, states, federal government have nothing to do with them. Class 2 games are your bingo style games or your non-house bank card games. So a lot of people are surprised to know when they go to the casino, some of those slot machines aren't really slot machines. There's a little bingo card and you're actually playing bingo. So those are allowed to the extent that the state allows any other entity to operate those. So if the state allows even like charity bingo or something like that, the state has to also allow tribes to engage in class 2 gaming. Class 3 gaming are your like kind of like big ticket things, right? They're your real slot machines. They're your like house banked poker, house banked blackjack, ball and dice, can be, roulette, all that stuff, right? So those are your like traditional casino style games. And those are only allowed if the tribe and the state come into a tribal state gaming compact. And in some states, including Oklahoma, pursuant to those compacts, the tribes end up paying what are called exclusivity fees, which is the tribes are paying the state to be the only entities that are allowed to operate those class 3 games. Okay, so in Oklahoma, we got class 3 gaming in 2004 with State Question 712. And this created the Model State Gaming Compact and allowed for class 3 gaming. The compacts were set to expire on January 1st, 2020, but there was a provision that said they would automatically renew for successive 15-year periods if, and this is the exact language from the statute, organization licensees or others are authorized to conduct electronic gaming other than pari-mutuel wagering on live horse racing pursuant to any governmental action of the state or court order following the effective date of this compact, right? Which is like obviously super clear language. So basically, the controversy arose out of that particular provision. The Governor Kevin Stitt, said that the compacts were set to expire on January 1st, and he wanted the tribes to have to come and renegotiate those compacts to pay higher exclusivity fees. And the tribes disagreed with that. Okay, I think we all know that, right? We watch the news. So what ended up happening in the federal courts was the federal court determined that State Question 712 also allowed horse racing tracks to operate electronic gaming. And the Oklahoma Horse Racing Commission subsequently promulgated rules to allow and regulate that electronic gaming at horse tracks. And the court said, well, that was a governmental action, right? It was an executive agency acting to promote and promulgate, allow these organizational licensees, these horse tracks, to have this electronic gaming. And that was triggering of this clause. So therefore the compact's automatically renewed. Okay, so that's settled in federal court. And last week, Governor Stitt's office announced that they would not be appealing that decision to the 10th Circuit. So that stands currently. So that's decided, but in the midst of this controversy, another controversy that I actually find more interesting arose. So during the pendency of that federal lawsuit, Governor Stitt negotiated and signed 4 new gaming compacts with the Comanche Nation, the Otoe Missouri tribe, the Kialiji Tribal Town, and the United Kituwa Band. And these compacts were interesting because they included language that was not consistent with current law, with the current Tribal State Gaming Act. The Comanche and Otoe compacts particularly allowed or purported to allow those tribes to enter into event wagering. So they could do sports betting, essentially, is what we're talking about here. They also included some provisions to allow those tribes to have off-reservation gaming. Whenever a tribe wants to have a casino that's not within their jurisdiction, they have to go through a special process with the Department of the Interior. And essentially, the governor was promising that the state wouldn't try to object to that if they wanted to do it, okay? So these basically expanded or purported to expand the scope of what is legal under the law in Oklahoma as far as gaming is concerned. But never amended the statute. So this is the law that provides the offer of gaming, right, between the tribes, and it provided a model gaming compact and said that if the tribe and the state entered into the model gaming compact, that nothing would need to happen. But if they used additional language, it would be provided that the Joint Commission, which is a commission in the House of Representatives and the State Senate, would have to approve it. And the governor contended that he had the authority to enter into these gaming compacts with the Comanches and the Otoes and the Kialijis and the UKBs because the Oklahoma State Constitution grants a strong separation of powers, and it's kind of the governor's role to enter into these compacts with tribes. And he relied upon this Oklahoma's Attorney General opinion from 2004, which said that that Joint Commission approval was actually unconstitutional under separation of powers. So that Attorney General opinion relied on a Kansas case called Snyder versus Bennett, which was adopted by the Oklahoma Supreme Court in the Oklahoma Department of Transportation. And that dealt with legislative approval of certain grant application notes of the Department of Transportation. And the court held that the legislature requiring approval of executive functions was a violation of the executive's powers, right? That was infringing on the executive's authority. But there was, because we're talking about Kansas law here, we've already brought it in, there was another Kansas case called Finney that basically had almost the same exact facts as we had here in Oklahoma, and that dealt with the Kansas governor making compacts with tribes that had a lot of different terms than what was currently allowed by statute. And the Kansas Supreme Court in that case said that that was actually the governor, the executive, infringing on the legislative's separation of powers and the legislative powers, because that was the governor trying to make law and change law. So, and this is pretty consistent with Oklahoma, because in Hart versus Warner, a 2007 case, and in State Ex Rel Oklahoma Tax Commission v. Jackson, which was a 1980 case, the Oklahoma Supreme Court said that the legislature is vested with a supreme legislative power that is rebutted only by the state constitution or federal law. So the legislature is the only entity that has the power to change what the law is. The legislature has the authority to make policy. And that was, of course, reflected in the Supreme Court opinion, which said that, and the Supreme Court literally said that this question implicates the core notion of our constitutional structure, separation of powers. And they said that the legislative branch sets public policy and that the governor's role is to execute that policy, not to make changes, right? And the court said that the governor has to negotiate the compacts within the bounds of the laws enacted by the legislature, including the State Tribal Gaming Act. And the Supreme Court also did note that even the Joint Committee would be, like, the Joint Committee couldn't have cured this problem. Like, if these compacts had gone through the Joint Committee, they would have still been invalid because they didn't change the legislature, like they didn't change the statutes. So anyway, the final result of this is still kind of up in the air. The court in the first case, because so the Senate Pro Tem Treat and then the Speaker of the House filed suit against the governor seeking to invalidate these compacts. And the Oto and the Comanche Compact was invalidated per the Oklahoma Supreme Court. However, the Comanche Nation is still asserting that their compact is valid because the Oklahoma Supreme Court does not have the authority to invalidate their side of the compact. And so there's actually currently pending federal litigation in the DC District Court against the Department of the Interior because the Department of the Interior deemed approved these compacts. And the Supreme Court actually separated the case of the Kylie and the UKB compacts because, like I said, they contain slightly different language. And those are actually still pending before the Supreme Court. They have not issued an opinion yet. So it'll be interesting to see, like, just how far, if the court decides to say, like, well, the governor did have this authority, right? How far does the governor's authority to negotiate these compacts extend? And how far does the legislature's authority on changing the law extend? So that's the conclusion of my presentation. And I tried not to go too far over 10 minutes, but I would happily welcome any questions whenever that time comes, but thank you.
Right. So thank you very much. I really appreciate you honoring your time restriction. Now, I want to note here, for those who just got in, my battery on my iPad seems to be misfunctioning. So if I go blank, or I'm actually going to walk away and try to get on in another device. So Christine, you'll be having to let me in another device and doing a presentation at the same time. So Christine, would you move forward with your presentation? You can only take up to about 10 minutes or 15 or 30. Please unmute. There you go. Unmute.
The title of my talk is Understanding the Midnight Rider, Native American Environmental Policy in Oklahoma. And in a lot of ways, it kind of echoes some of the issues that Jacinta talked about a minute ago. And I started this presentation, it's based on some work I did that I presented at the American Political Science Association, but I carved out a small piece of it for this purpose. So this is a little badge that one of my students made me in Oka, is water in Choctaw. So anyone who knows about Oklahoma knows about Oka and water and how important water is in Oklahoma. And I also wanted to give a brief land acknowledgement, acknowledging the tribes who were here before any of us non-tribal people. So this research was funded somewhat by the Oka Institute that's housed at East Central University, and I worked on it with a colleague, Terry Becerra, in 2018 and 19. And we also had Native students who were working with us on this, including Heather Hall, a Chickasaw student, William Palmer, citizen Potawatomi, and Michael Barnett, who is a Cherokee citizen. And we looked at 8 different tribes, and we interviewed tribal officials from each of these tribes, and then visited cultural sites and museums and such, just to learn as much as we could about each tribe. So we've heard a lot about McGirt. We were doing this research before McGirt came along, but obviously McGirt creates a whole different context for looking at environmental regulation. I became interested in this topic because the state of Oklahoma, when it's awarding permits, looks for beneficial uses of water, and they do not typically consider like sustainability or anything about conservation as part of a beneficial use of water. And it really struck me that that was very much different than how Native people see water. Like conservation and sustainability would be first and not even on the list. And so tribes see water like for cultural purposes, for making sure that they nourish plants and animals that need the water for sustainability for cultural uses. So that's very important to tribes. And we've also seen continual water conflicts between tribes and cities in the state of Oklahoma, and then states like Oklahoma versus Arkansas for water quality, Oklahoma versus Texas for water quantity. So we have lots of instances where tribal rights are not considered. In fact, some of those conflicts, like the one between Oklahoma and Arkansas, kind of initiated the idea that the tribes' rights were not even being considered. Arkansas kind of threw that out as sort of a red herring to kind of put a stop to the litigation by saying you have to define tribal rights before we move forward. And that kind of triggered tribes such as the Cherokee Nation to start looking at what rights really did they have regarding water that was impounded in reservoirs, pipelines that crossed tribal lands, where tribes literally were not consulted during any of the construction phases of these reservoirs or pipelines. So many of you know the history here. There were some tribes that had ancestral homes in Oklahoma, but 38 tribes have been removed from Oklahoma to Oklahoma from other places throughout the 1830s to the 1894. There's basically hardly any man-made lakes in Oklahoma. So just consider working out the land rights for creating 200 lakes. And most of the lakes are on lands that are tribal lands. And then the tribes were not even like talked to about, hey, would you like to have a lot of your land underwater now? Like that was not even a thing, because mainly the political weakness of tribes throughout the dam building period. Tony's back twice, I think. I'm muting you so you don't have the echo there. So we know that Oklahoma is totally crisscrossed with oil and gas and water pipelines. The early context of what I'm talking about, like termination policy, was still in effect until the 1970s. And then we cross into 1970 and we see the beginning of the self-determination era. One of the reasons I wanted to bring this up and rehash this well-known history is I think it's very fascinating that the rebirth of tribes in terms of self-determination, which really happens because of Richard Nixon and his recognition that tribes should elect their own leaders and they should run their own programs. Tribes' power grew up at the same time as the creation and the growth of the Environmental Protection Agency. The EPA is not the BIA. The EPA was brand new in the 70s. It had none of the old baggage that the BIA had. So it kind of left an opportunity, something Left-Hand Begay calls an undefined relationship, so that the tribes could work with the EPA. And in fact, if you look at agencies within the federal government, EPA has one of the best relationships with tribes of any other agency. So when we look at who should enforce environmental protection on tribal lands, like going back before the self-determination era, tribes literally could not have done this. They didn't have the capacity to do their own environmental regulation. But post-1970, especially post-1988, when we see the National Indian Gaming Act passed, we actually see tribes developing the capacity to do this environmental regulation. They had the inherent sovereignty all along, but maybe not the political capacity. States, as we've learned in McGirt, like this is not something we understood very well, but certain states like Oklahoma had no jurisdiction at all to regulate tribal lands because of the sovereign to sovereign relationship between the tribe and the federal government. The state really didn't have an official role, although they filled the vacuum, they filled the gap. The federal government had the authority to regulate, but very little will to do so. So we just have this strange vacuum in these relationships. Corntassel and Whitmer call the relationship between states and tribes forced federalism because, legally speaking, tribes should not have to deal with states at all. But there are several instances where they're forced to have relationship with states because, just practically speaking, they have to get the job done. But then also we see certain legislation that forces this relationship, such as the Clean Water Act, which says tribes can get treatment as a state if they get permission from the state and they work with the state. And then also Indian Gaming Regulatory Act also says tribes have to compact with states in order to have the right to compact. So I'm from Nebraska. The Nebraska tribes wanted to be gaming tribes. They never could get the state of Nebraska to compact with them. So they have not been able to develop any gaming operations. Oklahoma, on the other hand, as we just saw in Jacinta's presentation, was able to compact since 2004 and create fantastic facilities, netting over $5 billion a year in revenue that the states are required to reinvest in the state, in the people, in the programs, in their tribes, and in Oklahoma. So that's really a kind of a win-win for the tribes of Oklahoma and the people of Oklahoma. When the compacts came up for renewal, Governor Stitt just said they don't renew. No one agreed with him. We saw that in Jacinta's presentation. No one could even understand why. They were speculating like maybe God told him to do this. Like that, literally no one could understand why he wouldn't just recognize the fact that the compacts, you know, here are the conditions under which they renew. The conditions were met, they're renewed. It should have been easy peasy and move on, but that's not what happened. In Oklahoma, the environmental regulation of tribes could be done by tribes. There's a mechanism in EPA procedures for treatment as a state. Tribes might be able to write their own water quality standards. Pawnee Nation has tried this. Citizen Potawatomi Nation has tried this. The state of Oklahoma has not worked with either or any tribe to finish the process of treatment as a state. Now, this isn't a huge deal because many other states have not taken advantage of this program either. So only 13% of the 330 tribes where it would make sense are actually doing this, 44 out of 330. So it's not really a big deal, but we have in Oklahoma tribes who want to do this in the state of Oklahoma who really has no authority here is saying no, that they're not going to participate. So Oklahoma tribes, which have a bigger landmass and where it might really make a huge difference for environmental regulation, are not given this opportunity. So just to show you, like I know you've all seen this map because of McGirt and all of its implications. So you see where the Creek Nation is, but this whole outlined area are places where, you know, authority, jurisdiction is really in question now. And these are all places where tribes would like to have the ability to regulate their own water quality standards, but they're not being able to. So if tribes could regulate, what would they do and how would they do it? I know I don't have time to go through all of this, but there's intertribal workings where states could work within a tribe to try to regulate water or do water testing, share information. We have tribal collaborations among tribes. So Chickasaw Choctaw Water Settlement's a good idea or a good example. The collaboration of the tribes in the far northeastern state, part of the state where they work together on recycling programs, that's a great example. Forced federalism so the state of Oklahoma and tribes, so there's a lot that they could do to work together. Sovereign to sovereign relationship with the federal government, for example, tribes can provide their water monitoring data to the EPA. They can get treatment as a state under the Clean Water Act. So this is with the federal government. And then there's also a movement, especially looking at Walter Echohawk with the Pawnee Nation. He's really interested in trying to integrate the Treaty on Indigenous Peoples into state and local and policy, because the federal U.S. government's not going to ratify that treaty. But he's like, well, let's just take the principles and incorporate them into our local law. We can get to the result of it without having to work with the federal government. So there's a lot, basically, there's a lot of opportunities for collaboration. And I think it's safe to say that if tribes could regulate their own environmental quality, they would raise water quality standards. They would probably reduce amounts of water that would be sold or sold specifically. So in conclusion, forced federalism, like forcing tribes to work with states via compacts, fails tribes. This is diminishing their sovereignty by forcing them to work with the state of Oklahoma, where they don't really have an official relationship. And then especially in light of the breach of the Gaming Compact, which is like the financial lifeline for tribes, and then to have Governor Stitt like disrupt that. Like, the law loves stability. We love predictability. So if your source of income is disrupted, how are you going to plan for the future? So in this post-McGirt world, the solution is lots of compacts between the tribes and the state of Oklahoma. But the state has already breached its most important compact. If you had to rely on compacts, would you be super secure in your relationship with the state of Oklahoma? Like, I think it's a real toss-up for tribes. McGirt opens the door for tribes making and enforcing environmental policy. And let me jump ahead here. July 22nd, almost immediately after McGirt, Governor Stitt asked the EPA to strip tribes of their environmental authority. He didn't tell this to tribes. He told it to people at the Farm Bureau that this is what he wanted to do. And Director Wheeler pretty much just took that and agreed that he would grant the request. And now tribes have been stripped of that ability that would exist in any other state. So the EPA's decision slammed the door shut for tribes being able to do their own environmental regulation. So what happens if Joe Biden is elected president? Well, one thing that could happen is his new director could reverse this decision, and then maybe tribes would have the ability to have more say-so. And I'm not saying necessarily that they should control everything, but they weren't even at the table, and they still aren't at the table about what's happening with the McGirt aftermath. If you've seen the Governor Stitt's commission on what we're doing in post-McGirt world, it does not have any tribal people on it. It's like Larry Nichols and other oil and gas executives. And truth be told, that's who's the most concerned about what's happening here. Because if tribes were able to control these things, they might just say, come get your pipeline, remove your wells, like that. I mean, that's very possible that could happen. So I can understand why oil and gas is concerned, but the way forward is not excluding tribes from this conversation. It's inviting them in to collaborate and talk to, the different parties and make sure that there's a mutually beneficial outcome. So another thing I want to warn about is backlash, because a lot of times you say, oh, wow, we have this great advance in the law. Well, especially in Indian law, advances can lead to huge backlash. And so one thing that Congress could flat out do tomorrow is just disestablish reservations with one piece of legislation. They could even end federal recognition of tribes with one piece of legislation under the plenary power they have. So I worry when people push too hard for things, they could end up creating a backlash that would give them a result that would be less than optimum. So this is my summary. No government except the tribes has the will, because they care the most, or the means, because they have the money, to make and enforce environmental policy in Oklahoma. The states aren't going to do it. The federal government doesn't have the ability to do it. They're not going to, be that close. Clean water is life. This is a quote from tribal leaders. They're the ones who care. They're the ones who have the capacity, and they're the ones who would get the job done.
Thank you, Christine. And now we have our third panelist is Ryan Haney with the Oklahoma Council of Public Affairs discussing Oklahoma State Question 805. Welcome, Ryan.
Hi. Yeah, so it feels a little bit weird to be talking about State Question 805 because the results are in and they were not good for the Yes campaign. In fact, there was not a single county that voted in favor of it, although there were a few that got close. But even urban Tulsa voted it down with significant margins. So. I will just briefly kind of discuss what it was designed to do and then talk about some of the opposition that we faced. Myself and OCPA did come out in favor of State Question 805. And so I'll talk a little bit about some of the big objections and kind of where do we go from here. In some way, we're still trying to figure that out. What the legislature is going to be open to with State Question 805 being voted down the way that it was. So State Question 805, sort of at its core, is a criminal justice reform measure that is aimed at repeat offenders who have not committed a violent crime, and that is something I'll get into a little bit later. But what it says, so if you think about Oklahoma criminal law, each offense comes with a sentencing range, and that range can be 0 to 5 years, or it can be 2 to 7 years, or 15 to 20, or 25 to life. And so that sentencing range is designed to factor in aggravating and mitigating factors, as well as factor in criminal history. And about 20 years ago, when states throughout the country were going tough on crime and instituting these, we typically think of California's 3 strikes and you're out rule. What they did was they said if you commit 3 violent crimes, you're getting a life sentence. And so other states throughout the country started to implement these kind of statutes. Oklahoma did one better, and so we said, well, we're going to have sentence enhancements, and we're going to have sort of our own 3 strikes and you're out, but we're not even going to limit it to violent offenses. We're going to have sentence enhancements for all kinds of offenses, for drug offenses and property crimes and things of that nature. And so what it has done is, I think probably everyone on this call recognizes that Oklahoma has an incarceration problem. Depending on the time frame you're looking at and which statistics you're looking at, we're anywhere from 46th in incarceration to dead last, and we're almost always consistently last when it comes to how we incarcerate women. And so in an effort to kind of undo this, Oklahomans for Criminal Justice Reform and several other groups have undertook to pass some criminal justice reforms. In 2016, 780 and 781 passed, which reduced several felony crimes to misdemeanors. They were drug crimes and property crimes. And then there's been some legislation where there was a huge commutation. And so what 805 intended to do is we said, well, if you look at our incarceration numbers, we don't think that's reflective of who we are as a people. And I actually wrote an op-ed in the Oklahoman to this effect, right? If I thought that Oklahoma women were the least law-abiding women in the country, like I would move my daughters and my wife out of the state and my son out of the state, because I would want him to have better prospects. But the reality is, I don't think that those statistics reflect who we are as a state. And the reason we incarcerate so many people is because is in part because we are incarcerating them for much longer than other states. And so I don't have the statistics right in front of me, but the statistics for property crimes and drug crimes in particular are pretty daunting. It's somewhere in excess of 60% higher for drug and property crimes than the national average. And so what State Question 805 was designed to do was to say, well, for people who have never committed a nonviolent offense, whether it's, they can't have a prior conviction that was violent or the current charge be violent, we would eliminate sentence enhancements. And what sentence enhancements do is they allow prosecutors or judges or juries to sentence beyond that range that we talked about at the beginning. So you might have a crime that carries 0 to 5 years, but if you've got a prior conviction, it might give you all of a sudden a 2-year minimum, and it might extend the maximum up to 7 or 10 years. And so State Question 05 sought to eliminate those enhancements for nonviolent offenses. And I think, so there were 2 main objections that we saw, and they were primarily raised by law enforcement, who I think probably felt like they did not put up enough of a fight on 780 and 781, and so they came out in full force to oppose 805. And then we also saw domestic violence advocacy groups that represent victims of domestic violence come out in force against it as well. And there were two main arguments about why they felt like State Question 805 was bad. The first is that it amended the Constitution. That's sort of that's an objection that I kind of get. I think especially in light of, well, and so full disclosure, OCPA's constituents are right-wingers, right? And so those are the people that I present in front of. I go talk to Republican women's groups and Tea Party groups and that sort of thing. And especially after Medicaid expansion passed, there's at least in our constituency, a new resistance or a stronger resistance to putting things in the state constitution. So I sort of understand that, but the reason that it was done that way was to keep the legislature from tinkering with it. And so I say tinkering with it, that's probably a generous way to put it. I mean, quite frankly, we were afraid that they would gut it, especially in light of what's happened with some of the efforts to undo 780 and 781. The other issue that got just a ton of traction was this idea that you could draw a dichotomy between violent offenses and nonviolent offenses. And they went out and they found just a bunch of offenses that sound really violent. My favorite of which was child trafficking, which if you kind of dig into the Oklahoma statutes, what you find is that child trafficking is essentially an illegal adoption. It is not what we typically think of when we hear the phrase child trafficking. Human trafficking, which children are human and they fall into that category, is a violent offense that 805 would not have affected at all. But in any event, I did the research on this violent offenses list. 805 did not define what is violent and what isn't violent. It actually used a statute that was enacted in 1984. It was signed into law by then Governor George Nye. In 1984, we had the same problem we have now. Like, this problem is not a new problem. The prisons were overcrowded in Oklahoma, and the legislature passed a law called the Oklahoma Prison Overcrowding Emergency Powers Act. And what it said was, when the prison capacity got to 95%, DOC was to start letting people out who had 2 months or less left on their sentence until they got back below that 95% threshold. And if 2 months didn't get you there, then you'd extend it to 4 months. But what the legislature did was they came up with a list of crimes that they essentially said, no matter what happens, no matter how full we get, if someone is convicted of one of these crimes, we're not letting them out early. And that's where we get this list of violent crimes. And what it is the list of crimes that punish conduct that we can all agree is always violent. Things like murder and rape and kidnapping and first-degree arson. And so what you find is that when you dig into some of these other crimes that are not considered violent, a lot of times what they're doing is they're punishing conduct that is so broad that it can cover both violent and nonviolent conduct. So for example, I mentioned that domestic violence advocacy groups were one of the big groups that came out against State Question 05. Well, when you start to think about what domestic violence is, it's not always what we think of when we think of domestic violence. We tend to think of husbands or boyfriends who beat up on their girlfriends or wives. but in reality, it's broad enough to cover roommates or a child who gets in an altercation with their parent. Oftentimes, parents don't want their children to be tagged with a violent crime, even if there was, you know, a physical altercation. In 2020, it can include homosexual couples where the balance of power is not as tilted as we might think of in what we sort of think of when we think of domestic violence. So there's, I think, good reason why domestic violence historically was not added to this list because they had 26 years to add it. The other thing is Oklahoma has a law that says if you are charged with domestic abuse and with and you have a pattern of domestic abuse, so they can show one other instance besides the charged instance, that person can face up to 10 years in prison. So that was one of the things that we were tasked with doing, was just trying to combat some of the misinformation and half-truths that were raised by law enforcement and some other organizations. The idea that 805 was designed to treat all offenders as though they were first-time offenders can only be true if you seek the max on a first offense. But Governor Keating, who a couple times debated one of my colleagues, Trent England, even as he was saying that, was also admitting that when he was a prosecutor, if he got a first-time offender, he might give them DA probation, and then if they come back, then maybe they get a deferred, and then if they're back again, then maybe they get a suspended, and only on the fourth or fifth time do they get any jail time, which suggests to me that even with the enhancements available, like, we're not treating everyone as a first-time offender. And of course, he was a prosecutor long before this enhancement statute was in effect. But like I said, it did not pass. I don't know where we go from here. As I traveled the state and talked to different law enforcement officers and just sort of voters, there was large agreement that reform is necessary, but that this was not it. And so I'm going to be interested to see in the coming months where these people feel like criminal justice reform is going to, what reforms are they willing to not only get behind, but then lobby the legislature to fix? Because as much as the district attorneys would love to tell us, or they love to tell us that they don't make law, that they just enforce the laws that are written, they are a huge lobbying force at the Capitol. And so it'll be interesting to see what kind of reforms they are willing to get behind and lobby the legislature to pass. So I don't have much else to say other than kind of what happened, but I'm happy to answer any questions if anyone has any. Did we lose the moderator?
I'm looking. I don't know that I see him on the list. Okay. Yeah, I don't see that Tony's still with us. I had one question for you, and that relates to the pairing of 805 and 814 on the ballot. Do you think that one drug the other one down, or vice versa? Because sometimes they all pass or they all fail. So sometimes it's the kind of like that ballot effect. Like the voters just go in with the mindset no on the initiatives, like they don't want to split their vote.
I think that is possible. Like I said, I think at least for the people that I talked to, 802, I soured them a little bit. And so I think people went in saying, let's just vote all this stuff down. And the legislature is where law needs to be made. And again, I sort of understand that, but yeah, I honestly think that if 802 had been on the ballot in November, it would have gone down as well. So yeah, I don't know. And then the other thing is there wasn't really, while there was a definite yes and a definite no campaign on 805, 814 really didn't have a coalition either behind it or against it. So there was, I think, massive confusion and misunderstandings about 814. I know I saw a lot of it just sort of as a as a as a bystander, where people didn't, I don't think they understood. They sort of understood that it was tied to Medicaid expansion, but didn't really understand how. And so I think that I just don't think people really understood what it was even aiming to do. So that was a weird one.
So maybe it got pulled down by the other one because there was
It's
just a lot of
possible. Yeah, there's no telling.
yeah, yeah. Well, we have a few minutes left, so we have time for questions for any of our presenters. So is there anyone out there who would like to ask a question?
Question about the 805.
Go for it.
Can you hear me?
Yeah, go ahead. Answer.
Oh, good. Okay, so for 805, I'm wondering if the fact that Oklahoma has straight ticket voting, you didn't have to turn your ballot over to see the questions. Do you think that that had an impact on the number of votes? I'm curious about if there's a big difference between the total number of people that voted for either of those ballot questions compared to how many people voted for president. Is there a big difference? Was it a lot lower, or was it about the same?
I have not looked at the number of people who voted for the president and other offices, but it looks like we got about 1.5 million votes on 805. I don't know how that compares, but it was so lopsided that, I mean, I kind of assumed it. Maybe it's reasonable to assume that maybe they would have been split. I don't know. That's a good question.
I'll just say as a piece of information that this was the third highest turnout in Oklahoma history since statehood. So the most high was 72, Richard Nixon's reelection, and then the next one was 1932 with Roosevelt, and then this is the third percentage. Any other questions?
I will just say, I just looked up, it looks like the number of votes is very similar between the number of votes cast for the president and for 805. So I don't suspect that there were a lot of people not turning over the ballot, although there may have been some.
Okay.
Well, I'd like to ask Jacinta a question about compacts. Do you think that the bad relationship regarding the gaming compact is going to bleed over into renegotiating other kinds of compacts like tobacco or game or hunting or license plates?
I mean, I certainly hope not. But I mean, my understanding from, the conferences I've attended and what I've seen presented from people on the tribal side, is that there is a lot of concern about, how do we know, anytime you enter into any type of contract negotiation, any type of relationship like that, it's ideal for both parties to feel like they're fully respected and fully, coming at it with good faith. And I think that part of it was that the tribes felt very disrespected in the way that things were handled by the governor's administration. And so I don't know if that was just, I don't know what the reasons were for that. I think that the governor's administration just really felt like they were right on it. But I think that it was my understanding of what I've seen in other, Indian law conferences and presentations by people on the tribal side is that not only was it the insistence that the tribes have to renegotiate, but it was the way the whole situation went on, because sports betting is something the tribes have been wanting. I believe that legislation was filed 2 sessions ago in the House to allow sports betting to be put into tribal gaming compacts. So that, I mean, this is something that tribes have been interested in. And I certainly think that, you know, and again, I don't work for a tribe. I don't represent any tribe. This is just sort of like my own, like what I've taken away from conversations that I've heard. But it seems pretty clear to me that the tribes would have been, most of the tribes would have been happy to enter into some type of negotiations if it meant getting some more, you know, on their end. I mean, they're willing to pay for sports betting because sports betting brings in a lot of people. So I think it just having a tenuous relationship is going to chill any contract, whether that be between states and tribes, be that between business, I mean, you know, anybody, having that kind of like, okay, but you've a little bit tried to burn us before, is gonna, you know, unfortunately that's going to put a chill on things. So I hope not. I hope, you know, and I talked a little bit about this in the Supreme Court discussion about McGirt, but prior to this conflict, the state and the tribes of Oklahoma have been able to do a lot. Like you said, lots of tobacco compacting for taxes, fuel compacting for taxes, lots of cross-step agreements between state and tribal law enforcement. You know, tribes provide a lot of assistance to non-tribal members. The legislature approved more compacts for, you know, emergency services last session between tribes in the state. So there's a lot of really great things that have been able to happen when tribes in the state of Oklahoma work together. So I certainly hope not. But I mean, I don't know, because again, like it is difficult when you're not really sure where the other side's coming from if you don't know that you can really predict what's going to happen next.
Excellent. I think we have time for one more question from the audience.
I have a question. Do you think the recent Supreme Court ruling will have any bearing on any of the tribal compacts going forward, and then trying to come with an agreement on both the judicial side plus the gaming compact side?
Sure. So, and that's a good question. The gaming and whether or not you have a reservation doesn't really have a lot to do with whether or not you can have a gaming compact. So that won't really affect anything to do with the compacts themselves. However, I don't know the answer to this question. This is something that I've sort of been talking about with colleagues, is because some of those compacts, which are still somewhat in play, that were signed by the governor, that were at issue, contained provisions to allow off-reservation gaming. Some of those provisions allowed off-reservation gaming like near or within potentially other tribes' jurisdictions. So if it turns out that some of those tribes have reservations, I mean, there might be, but I'm not personally aware of any precedent of a situation where a tribe has tried to put a casino inside another tribe's reservation. So that could be a mess. I don't know. Like, I mean, but it's all very hypothetical, because to my knowledge, those tribes have not actually obtained that land or anything yet. And I looked to see, the last time I looked, there weren't land to trust acquisition applications with the Department of Interior. But it's not, they're two separate issues, but you know, depending on how those compacts end up with the off-reservation gaming, it could, you know, I don't know. It's up in the air.
I would just extend a little bit what Jacinta's saying, which is it kind of changes the bargaining position of tribes, because potentially they could have a lot more leverage vis-a-vis the state, because the state, for example, really wants to protect oil and gas. And now if the tribes have a way to change that context, then maybe the state will have to be more conciliatory to tribes to make sure that they keep tribes going along with the current structure. So I think it gives a lot more leverage to tribes because they have a lot more power. A lot more things are going to have to be negotiated. So not directly, but indirectly, suddenly they become a lot more powerful. Well, I think we're about 5 minutes to 4 o'clock, so we should probably wrap this up. The next panel is going to be public administration. And you've got your link in your PDF file, and we'll see you in the next session. So thank you so much to our panelists and to all of you who participated in this great session. So thanks, everybody. We'll see you in the next hour.
Thank you.